Welcome everyone to the inaugural edition of the CBME Quarterly Seminar Series. I'm Mathavi, a research associate and also a PhD candidate here at the Center for Biomedical Ethics, and I will be facilitating today's seminar by Prof. Dunn. To briefly introduce the speaker and the title and subject of today's talk, Dr. Michael Dunn is an associate professor at the Center for Biomedical Ethics. Prior to joining NUS in January this year, Mikey spent 13 years at the Ethox Center in the University of Oxford. His current research projects explore various ethical aspects of community-based and long-term care practice, policy, and law in Singapore, the UK, and internationally. Today, he will be speaking to us about the concept of the human element within the legal framework and deliberative processes pertaining to mental capacity law. With that short introduction, I would like to hand over to Mikey.
Hello everybody, and thank you Mathavi for that kind introduction. It's wonderful to be the first speaker in our new CBME seminar series, and we hope many of you will continue to join us from all over the world in future seminars. We're hoping to convene a seminar every 3 months, and we'll keep you all informed on what we have planned. So as many of you know, after working at the University of Oxford for the last 13 years, I moved over to Singapore in January this year. So it's an excellent chance to share some of my ongoing research with you all. It's wonderful to see such a large audience on the call, and especially a wide range of people from different professional groups across Singapore. My talk today focuses on one of the papers that I've been working on with colleagues back in the UK as part of a large 4-year research project called Judging Values and Participation in Mental Capacity Law. And we're due to complete the project in June this year. This is a topic close to my heart. I've been conducting research on the ethical and legal aspects of mental capacity and substitute decision making for the last 18 years, from day one of my PhD essentially. I'm particularly interested today in thinking about how these insights resonate comparatively and locally. Do similar themes apply in the application of the Singaporean MCA in courtrooms here, or are there differences? Does the account given by legal practitioners resonate with local clinicians, who are also tasked with making value judgments in determining the best interests of people lacking mental capacity? I hope we'll be able to discuss those questions together after the presentation. Before going any further, I'd like to acknowledge the investigators and wider research team who have contributed to much of this work. So in that sense, the talk I'm giving today is very much a team effort, although anything that's erroneous or not at all convincing is of course entirely my fault. I'd also like to express my thanks to Mr. Yuen Chong, a local barrister, who's heavily informed my understanding of the application of mental capacity law here in Singapore. The focus in this project is to critically assess the ways in which values take shape in mental capacity law practice, and how the person lacking capacity does, and should, participate in legal proceedings. The project incorporates a range of both theoretical and empirical questions, and it's one of the empirical outputs of the project that I'll be speaking to today, aiming to, in part, answer the first question here. Before I move on to the substance of the talk, I did want to briefly draw attention to our various project outputs, not least because my topic today is developed further in subsequent papers. We've published a position paper for the project and 2 theoretical papers critiquing 2 specific approaches commonly adopted in, or required by, the application of the Mental Capacity Act. That is, the role of the balance sheet in making best interest decisions, and the status and legitimacy of wise and unwise decisions. The remaining academic papers and books in preparation are described here. And the human element paper listed first is the focus of today's talk. This is very much a work in progress, and we're working on the paper currently. The subsequent 5 papers all dovetail out of this main empirical piece, documenting mental capacity law practice and articulating various related ethical and empirical claims, most of which can be traced back to this core theme of the human element. So the title of today's talk is The Human Element in the Social Space of the Courtroom, Framing and Shaping the Deliberative Process in Mental Capacity Law. A bit of a mouthful, but I hope to give you a sense about what I want to cover.
I've added here a quote from one of the retired judges that we interviewed to give you an initial sense of where my analysis will be going. But to start us off, I want to spend a little bit of time contextualizing this talk by introducing mental capacity law for those who are not familiar with it, as it applies in England and Wales. The Mental Capacity Act of 2005, the MCA, is explicit in prescribing a values-based legal framework centered largely around the concepts of mental capacity and best interests. Singapore's 2008 MCA was modeled on the same statute, and so it's very similar, but not identical, in structure and content. The Specialist Court of Protection in England and Wales, established by our MCA, grapples with fundamental questions relating to the interpretation and application of the law's principled requirements. In practice, decisions made in the Court of Protection revolve around questions concerning the person, P's, health and welfare, or her property and affairs that are characterized by inherent uncertainty and complexity. This includes questions regarding the form of and weight to be given to conflicting values, such as the requirements to protect P's welfare or to attend to her subjective preferences and personal values in a substitute decision-making process regarding her best interests. Importantly, the MCA itself provides little guidance or clarity about how to navigate these questions, and judges in the court must conduct an evaluative discretionary exercise, ultimately resulting in a value judgment, framed, of course, in response to the evidence and arguments gathered and presented by solicitors, barristers, and other legal practitioners. The case law emerging within the court reveals how exercising these value judgments can be extremely difficult, and how they are frequently presented by judges as a clash between fundamental ethical values. I'm going to take one case example from the English context to illustrate the fact that adjudicating mental capacity law cases involves these value judgments. This is the case of a local authority in E in 2012. So in this case, the court was required to decide whether nasogastric or peg tube feeding would be in the best interest of E, a young woman with a long history of anorexia nervosa and many failed treatments to alleviate her condition. It was established that E did not have the capacity to make that decision for herself. The judge, Jackson J., determined ultimately that it was indeed in her best interests to be forcibly treated. That decision went against her expressed wishes as recorded, as well as the recommendations of everyone who knew her best, her parents and the clinical team, who both supported a palliative care route that the team had previously put in place. In this very difficult case, the judge described balancing the factors for and against treatment, where, as he put it, the balance to be struck places the value of E's life in one scale and the value of her personal independence on the other, with these transcendent factors being weighed in the light of the reality of her actual situation. In discussing the case for preserving E's life, the judge observed the following: we only live once, we are born once, and we die once. And the difference between life and death is the biggest difference we know. E is a special person whose life is of value. She does not see it that way now, but she may in future. The discussion of transcendent factors is notable, not least in the explicit suggestion that extra legal values beyond P's values must be considered in helping the judge to make what he considers to be the right decision. It's compounded furthermore by taking a counterfactual, P as she might have been, as a reference point from whom the relevant values might be drawn. And Jackson J., the judge, held the following in his decision: the beliefs and values that would be likely to influence E's decision if she had capacity are not easy to articulate. It depends upon the assessment of her true identity. Has she been ill for so long that her illness would remain part of who she is, even if she had capacity? Or is she still the person she was before anorexia took its grip? Looking ahead, will E always see herself as a victim? Or can she come to see herself as a survivor? In the end, only E can know the answers to these questions. I think we can agree that the judge's reasoning here is challenging and poignant. The judicial search for E's true identity is not made easier by the MCA. And despite the judge's claim that in the end only E can know the answers, the legal process in which he finds herself suggests that the law, as interpreted, if not as written, rests on a different premise, one where the judge goes on to establish E's authentic values by reference to a factually and historically impossible hypothetical construction of her, illustrated by subsequent remarks that the judge makes, including the following. There's nothing in E's statements to indicate a belief that if she were well, she would not want efforts to be made to save her. And E would by now be a doctor, and doctors often willingly accept high-risk interventions. But let us not forget here that despite engaging in weighty ethical reasoning of this kind, this is a judge who's taking it upon himself to apply the law in the way he thinks is legally appropriate here. So we get to a position where the skeletal framework provided by the MCA is being populated by a wide range of non-legal values that must be reasoned through and settled in resolving the case in the courtroom. So moving from the courtroom now to the academic setting, there's been a rapid growth in academic legal scholarship focused on the Mental Capacity Act over the last 15 years, and including in Singapore looking at its own act. For the most part, this body of scholarship has focused critical reflection on the case law produced by the legislation. The analyses have taken a number of forms, including doctrinal analysis of major judgments and focused ethical analysis of the arguments presented in the courtroom. Whilst contributing extensively to understanding the complex stances taken to govern and regulate the lives of people lacking capacity, I think these studies have been largely limited by their reliance on the post hoc legal rationalization for a decision provided by a judge in a published judgment. By definition, these sources prevent scholars from capturing the ways in which the practice of the law takes shape in the courtroom. In other words, the backstage picture that orientates and shapes the production of this final judgment remains elusive. So for a long time, we've known very little about how mental capacity law is actually put into practice in the courtroom, and how the legal and ethical values underpinning that practice are framed, presented, and digested, and how the various actors and stakeholders feature in this deliberative legal process. Now, in the last 5 years, research into mental capacity law has undergone what we might describe as a socio-legal turn. Looking at a couple of examples. The Open Justice Court of Protection project recognizes the need to increase transparency in how the Court of Protection operates, so that the public can scrutinize the court's work. The project functions to support straightforward access to court proceedings streamed live online, and encourages people who attend to write reflective commentaries on particular cases that have been observed. And here there's particular interest in authoring critical examinations of the arguments put forward in the court, and how those present and engaged in proceedings, and how the final decision emerges. I think in narrower academic terms, the value of this project lies in the way in which it facilitates observational study of the courtroom process, albeit with certain reporting restrictions in place, supplementing the previous reliance on published judgments as the sole source for analytic work. And scholars like Jamie Lindsay have taken this strategy further, undertaking observational qualitative research on proceedings in the Court of Protection directly. I think our work here extends this socio-legal turn in mental capacity law with a particular kind of ethical slant to it. We're seeking to examine how deliberative and adjudicative processes take shape in the courtroom from the perspective of specialist legal practitioners and judges. So we're about gaining an insider perspective of what practitioners understand their job to entail and how they seek to enact their perceived responsibilities in their legal work. Now, in so doing, and because we're a team of ethicists, not just lawyers, we're particularly interested in how values feature in these discussions, from where they are sourced, how they emerge at the table, how they function to shape legal arguments, and how they're accommodated in the decision-making process. Hopefully we'll cover some of those topics as we go. The structure of the rest of my talk is as follows. I'm going to start, I'll rather go on to briefly describe the methodology that we deployed in this work. I'll then move on to present the findings, revealing how legal practitioners and judges operationalize an overarching but only emerging sense of what we're going to call the human element as a means of both enacting and providing normative shape to mental capacity law in practice from their own perspective. The claim here is that the human element has two distinctive dimensions, a normative dimension and a performative dimension, which I'll go through in detail. I'll then consider how these dimensions have to be continually negotiated in order to manage recognized challenges associated with both socio-institutional expectations around professional hierarchy, evidence, and expertise, as well as a countervailing normative commitment in the court to objectivity. Rather cheekily, I'm going to conclude without a substantive discussion. I'm going to raise a number of questions that I hope will shape our discussions together after the talk. So methodologically, what did we do? So following approval by a research ethics committee, we adopted a purposive sampling strategy to recruit participants we thought were best able to inform our research questions. We undertook semi-structured, in-depth qualitative interviews to enable focused but conversational discussion. We adopted thematic analysis to identify key themes emerging in the data using a range of coding strategies, which I won't go into any detail now. The semi-structured qualitative interviews that we undertook were with 56 legal practitioners in England and Wales. 44 of these were either barristers, solicitors, or other relevant legal practitioners with a recognized specialism in mental capacity law. The other 12 participants were retired judges who had extensive experience of adjudicating mental capacity disputes, either previously as judges in the Court of Protection or across the various courts of appeal in England and Wales. Unfortunately, we were denied access to sitting judges by the Judicial Office, largely on the grounds of rule of law considerations, i.e. the argument presented was that judges should speak only through their judgments. It's not an argument I personally find persuasive, but that's a discussion for a different day. Participants were chosen to ensure extensive geographical reach across the whole of the countries, and at all stages we sought to ensure that our sample was broadly representative of age, experience, gender, ethnicity, and court setting, insofar as that's possible in a very elitist institution. The central theme that emerged from our data analysis was the view that the human element constituted a core distinctive feature of mental capacity law in practice in the court. The theme captures, I think, the main empirical insights from across the entire group of participants, incorporating perspectives of both barristers, solicitors, and judges. But the form of the explanations offered and the accounts given differ because of the different roles that they play in proceedings. So I'm going to turn now to the first component of practitioners' accounts of the human element, the overarching set of normative commitments they draw on to define good legal practice in human terms. First and foremost, participants observed how their involvement in mental capacity law cases demanded an approach, a set of normative commitments focused on collaborative, participatory, and open-ended ways of working together in the court. Different, they believed, to those strategies adopted in other areas of litigation. The realization of these commitments was dependent, in their view, on distinctive personal skills and character traits that they identified as critical to undergird and produce this normative vision of good practice. Participants identified that integral to the effective performance of their professional roles was effective communication with all parties and the adoption of a collaborative as opposed to adversarial or aggressive approach to their work. And this requirement was linked to a commonly articulated account of mental capacity law practice as the following. It's not about anyone winning or losing, one participant said. Rather, it's about looking forward and looking for solutions and asking, what's your destination? And then let's signpost the right route together. The necessity of this approach was connected to the messiness of personal and professional relationships seen as intrinsic to mental capacity law cases. This, coupled with the discretionary exercise demanded by the MCA, risked battle lines being drawn, with each party fiercely defending what they strongly considered to be P's best interests and rejecting, doubting, or minimizing any contrary positions. Various practitioners identified that through interpersonal dialogue and collaboration, these battle lines could be eroded or at least repositioned or relaxed. And people could be brought together with a shared objective of finding the right outcome for P, with all relevant views being openly shared. Consequently, the court was better able to obtain a comprehensive and truer understanding of P's values when all different voices were heard. Participants also clarified that competent interpersonal dialogue can help to navigate uncertainty about what decisions should be made for P, with all parties being left with a greater sense of ease about the final decision made. In addition to effective communication, participants identified the need for practitioners and judges to be able to engage directly with P. As captured by one participant, you've got to be able to have a difficult conversation with someone about a difficult topic or subject matter and be able to support them, to be able to feel in a place that they can communicate their views to you. It is quite a trusted position to be put into, isn't it? Emotional sensitivity, compassion, and empathy were also recognized as central to practitioners' views about good legal practice. Fundamentally, this meant people being able to place themselves in P's shoes, as well as other parties in the case, to find ways to see the world from a completely different set of values or ways of living one's life. In so doing, the judge and legal practitioner claimed they felt better able to respect and acknowledge their trusted position, as well as the impact they can have on someone's life. As one retired judge put it, I think a judge who lacks compassion is deeply flawed. In my view, compassion for the applicant or the defendant, as it may be in these capacity cases, is absolutely essential. The least that the litigant can expect is that the judgment should be, that the judge should be empathetic. Interestingly, this normative account of good practice and the skills and character traits identified as key to its enactment in practice were not solely developed within an account of the fundamental nature of the work involved in this area of law. Rather, the human element was articulated and grounded predominantly in relationship to the personal values and motivations of those who decided to specialize in this area of law. As one practitioner put it, I think I very much wanted to be involved in this because of the human element and the impact that you could play your role in making a better outcome. That definitely influenced the field of law that I went into. I think that I've always been somebody who's had a very strong sense of right and wrong and fairness, of it being fair. I think that's a characteristic I've had since childhood, so it probably influenced me. That probably influenced me into being a lawyer per se, and then having the human aspect of it, that pushed me in the direction of this work. Practitioners suggested this motivational grounding to specialize in mental capacity law made the kind of practitioner attracted to this area quite distinctive. The internalization and emphasis on other regarding values was a common theme we heard, such as the desire to help people and make a difference, the impulse to represent individuals who lack social power or with potential vulnerabilities, and so on. One of our participants said the following: I think anybody that I've ever come across that does this sort of work, I feel like we're all a common breed, really, and that you can always see that people genuinely are interested in actually helping people and using the law for good. I mean, I don't know that many corporate lawyers, to be honest, but I don't know that they would necessarily have the same motivation as what I think court of protection lawyers do. The idea that the profession of mental capacity law attracted people with the same values was repeatedly emphasized. It operated, as one barrister put it, as a small club of practitioners and judges in which someone who did not hold similar core values would be quickly identified, exposed, and ostracized. Connected to this was the ways in which participants perceived a distinction between those drawn to this area of law for the putatively right as opposed to wrong reasons. Those wrong reasons generally identified as self-regarding or financial, as opposed to more altruistic commitments. So in summary then, the human element of mental capacity law practice takes initial shape by reference to a set of normative commitments that seem to be generally shared between practitioners. There are some exceptions, but that's a general picture we found. These commitments are attuned to the complexities presented by hard cases, but they're also connected closely to the personal and motivational skills and traits that these individuals articulate to give an account of what a good mental capacity law practitioner consists in. In the next section, I want to consider how that normative prism is sought to be put into practice in day-to-day courtroom work by practitioners, showing how they try to meet two main goals. Before I get into the data, for practitioners, configuring the performance of their tasks meant recognizing that the complex cases to sort out had distinctive human dimensions that their skill sets and normative commitments enabled them to navigate. That included the importance of grappling with the dynamics of representing and advocating for persons who often lack power and agency, as I mentioned. And that led to an emphasis on the one hand, the unique subjectivity of P, the person at the heart of the case, being emphasized. And second, a perceived need to manage different forms of conflict that inevitably took shape in the social space of courtroom proceedings. And I consider those two orientations of legal practice in turn. So each mental capacity law case revolves around a person, P, whose mental capacity is either in question or where a declaration has been made, perhaps interim or final, that person lacks mental capacity. Accordingly, P may be prevented from exercising their own agency over particular decisions in their lives, rendering at times them powerless to direct their lives in meaningful ways. Participants highlighted the subjective impact of encountering the reality of these non-ideal circumstances. And I'll go on to show how they noted the conflict between the impersonal and formal procedures of the court with the purported legal imperative to keep the person at the center of things. Some practitioners described the law here as regimented or straitjacketed, and participants were generally ambivalent about whether legal proceedings could work with or against the person, sometimes empowering individuals, at other times exacerbating their powerlessness and lack of agency. Acknowledgement that the legislation and the court could worsen powerlessness, stigma, and discrimination led practitioners to argue to locate individuals right at the center of things I mentioned. For some participants, acknowledging the humanness of the person was a matter of viewing and treating that person as a subject rather than as an object, as a person with prospective subjective wishes, feelings, and values, as opposed to a diagnosis. And this process of recognizing the subjectivity of the person was described to a general overarching ethos, as well as substantive rather than just superficial engagement with that person themselves in relationship to meaningful participation in the proceedings. One practitioner described that process as inverting the telescope or the triangle, such that rather than everything being done to them, everything is all about it coming from them, regardless of how profound their impairment might be. Another practitioner detailed the dangers of pigeonholing people on the basis of a diagnosis. Okay, let me give you a clearer sense of the details here. Direct engagement with the person concerned was thought to have a reciprocal impact, insofar as it reminded practitioners and judges of the basic fact and gravity of making a decision on behalf of another person, and its potentially significant impact on that person's life. Recognizing the subjectivity of the individual was also found to have an experiential dimension through the process of physically encountering and engaging with that person. Practitioners claimed in various ways that the combination of putting the person at the center through physically seeing them in the proceedings, particularly through meetings with judges, could reiterate the weight of the decision and the subjective impact of that decision and proceedings on the individual. The general view here was, I think, captured in this sentiment that one practitioner said: if the best interest decision is swaying against their wishes and feelings, then it makes it a much harder decision when you're confronted with the person on whose behalf the decision is being taken. It's much easier to disrespect somebody on paper than in person. Engaging properly with P was connected closely to the overarching commitment of enacting an empathetic approach to practice. Several people confirmed that they actively tried to position themselves in such a way as to relate to and understand P's situation and fears, an often time-consuming and involved process of getting to know the real P. When discussing what steps they take to determine what's important to P, these people identified that they prefer seeing P themselves if possible, and in one health and welfare case, a practitioner and representative of the official solicitor said that she had spent a day with P, just talking and getting to know her. But for her to get to know us, because the other kind of aspect of this is that if we represent P, P has to be confident enough to open up to us, and that will take some time. What P says at the first interview or first meeting or first discussion may be representative of P's values, wishes, and feelings, but there may be far more which only comes out if P's got confidence in the people that represent him or her. Often these are very, very damaged individuals, and it's sometimes possible and sometimes not possible. But there is a concern of making sure that you don't rush the process or make assumptions, because they very often will not open up easily. So in summary, this account of the importance of foregrounding P points to interesting ways in which recognizing the human person and their subjectivity at the core of proceedings, and the process of coming into physical contact with the person, form part of a distinctive professional strategy. For practitioners, recognizing the humanity and subjectivity of P also involve them being attuned to the person's connectedness to other people, and the need to address challenges that can present with their within their relational lives. Now, there were some nuances in the way that participants understood P as being situated within relationships. Sometimes that would require acknowledging the constitutive nature of those relationships to the values of the individual. Other times, those relationships demanded further critical scrutiny. In general, practitioners describe the necessity of working from a subjective and relational perspective in order to generate a more holistic, evidence-based picture of the person's relationship context. At times, participants also spoke of less of an objective assessment and more of an intuitive feel for those relationships. Interestingly, this was for the purpose of doing what was best for not just P, but also for her significant relationships, therefore part of doing what might be optimally beneficial to P in the long run. Framed in terms of the value of collaborative and interpersonal ways of working, practitioners noted that the relational conditions around the individual and addressing these conditions within their work could either enhance or obstruct the practical focus on the person. They also had the potential to divert priorities in courtroom proceedings. The ability to understand complex relationships was therefore viewed as a central part of mental capacity law practice and adjudication, particularly in terms of managing the conflict that could feature in that difficult decision. More broadly, managing human conflict within a wide range of relationships was seen as central to mental capacity work amongst our participants. Such conflict has various intersecting layers and iterations between family members and P, between professionals and family members, between P and professionals. The presence of human conflict was not presented as being unique to this area of law, But our participants did view this as distinctive in the court of protection, the aim and manner of conducting the management of these conflicts. We might call this the pragmatics of generating a P-centric outcome, essentially enacting in practice the commitment to placing the person, P, at the center of the decision in non-ideal circumstances. Now, these pragmatics, according to both judges and other legal practitioners, involve collaborating and listening to different parties. They involve mediating and repairing relationships. They involve de-escalating conflict, distilling core issues, continually aiming to recenter the case around the person, and bringing different people on board to influence the process. One practitioner presented a very concrete example of how these pragmatics might be negotiated in difficult cases where professionals object to contact with P's family members who may have been unable to cope with caring for or had even neglected or abused P. That's not to listen to P and what P wants. In pretty every single case that I had dealt with, P has wanted contact, but not to be abused and not to be neglected. If P is able to express that, then what you do is you take that risk out of the contact and you make contact the best possible quality contact it can be. You don't punish the parents from what, from an objective point of view, is bad behavior and abusive behavior. If P wants that contact, you make it safe. But even beyond the pragmatics of taking a P-centric approach, participants spoke of additional reasons as to why their role in conflict management was so intrinsic to good work. And here the very nature of the cases, in their view, entailed a deep emotional investment of those around P, and the practitioners and retired judges we interviewed saw it as their role to attend to or alleviate these emotional ruptures in P's relational life. One practitioner put it like this: the court of protection work is very different from the other cases I do. You are just trying to do your best for P primarily, but also for everyone else. To the extent that there are conflicts, there are always conflicts in the family. You're trying to minimize those. It is actually quite a complicated endeavor that you're trying to heal, really. That's what I think. Whenever you have a situation, because I particularly do end-of-life cases in medical cases, the emotions are so very raw and powerful, and the situation is usually terrible, whatever anyone does anyway. I try and do my absolute best to certainly not exacerbate anything to the extent you can avoid it, but try and bring everyone together. I know that doesn't sound very legal to me, but I don't think they are very legal in general. I think they're about a lot more things than that. So though this practice's observation that efforts to bring everyone together falls outside a strict legal remit, it's not fully developed that point, I don't think, here, it does resonate with the broad commitment to engage in collaborative ways of working. Okay. So the ambiguous legal or extra-legal status of these more relational considerations is particularly noteworthy, I think, because it raises questions regarding the extent to which conflict management indicates a broader interpretation of what the purpose of the court is there to achieve. Although the importance of managing conflict through fostering collaboration was a predominant theme in the data, it also raises difficult questions as to the extent to which collaboration and consensus may become an end in itself, such that it potentially eclipses the focus on P in the process. One practitioner stated it like this: what I beat myself up more about is not getting everyone to agree. I don't care what the argument is, but if I get to the point where they're still disagreeing, I think, bloody hell, what else could I have done? Should I have done this? Should I have done that differently? As such, the emphasis on managing human conflict with an aim towards repairing relationships and fostering collaboration may have interesting tensions with a more forensic, critical approach towards judging and assessing P's relationships. Now, the aforementioned tension between the legal and extra-legal boundary work involved in articulating and acting the human element approach took shape in other distinctive ways. In particular, Practitioners described how they negotiated expectations in their work associated with operating in this very institutionalized legal setting that meant they had to apply certain rules of law fundamentally. And two particular aspects of difficulty they sought to manage here concerned, firstly, how they dealt with entrenched professional hierarchies, and secondly, how they navigated the expectations around the value of objectivity in both preparing and presenting arguments and in adjudicating the final decision. So first, practitioners recognized that professional hierarchies are internally and externally deferred to, affirmed and sustained in their practice. The tendency to defer to certain professional voices, and particularly voices in the medical field, was noted as a potentially invidious aspect of courtroom practice. One practitioner spoke of professional hierarchies, the medical mafia, and how the ranks sometimes close. Participants noted how a hierarchical structure is sustained through different levels in the courtroom and beyond. Interestingly, the hierarchical and status-driven nature of the legal profession itself was seen to provide external affirmation of pre-existing professional hierarchies, particularly in its tendencies to prioritize certain professional perspectives over others. So, for example, as it was put to us by one barrister, it's part of our legal hierarchy that people are often valued by how much they earn. And I think weirdly that tips into social work and probably into medical things. It is status which equivocates to how your salary is, rather than what's this person's actual experience that they can bring to the table. The same practitioner noted how professional hierarchies could give rise to tensions concerning purported expertise and the status of good evidence in the courtroom as follows. I mean, a lot of the time, the better evidence is from the nurse or the social worker than it is from the psychiatrist or the clinical psychologist or the neuropsychiatrist who's met them once, or even worse, they've never met them. They've just read the records. So I think there's a great problem. In a lot of the time, we're looking at people we believe are experts because they've got lots of qualifications, but really what's better for P is someone who knows them well, who's able to take an independent and impartial view. Sometimes the evidence that's really striking in a trial is from the community nurse who's worked with them, or the social worker who supported them, and not the medical experts. A rather major challenge to many of the people on the call, I'm sure, but that's exactly how it was described to us quite commonly in the interviews that we did. Okay, so as a result of these tensions, practitioners also highlighted the importance of maintaining strategies that heighten their proximity to P through a reassessment of whose evidence should be prioritized, and thereby circumventing what they saw as invidious social norms. A common strategy was to elicit evidence from more junior staff or those with regular contact with the person. They also noted how the professional hierarchy present in the legal process could actually be operationalized or co-opted to draw attention back to P. So one practitioner here had the interesting view that the judge meeting P, while simultaneously asserting and using the judge's hierarchical status, could be made use of to challenge professional experts, stating the following: if there's a dispute on capacity and there's a borderline dispute, it's really important for the judge to meet P, because simple reliance on expert evidence isn't enough, I think. Just because independent experts and experts say that someone lacks capacity or has capacity isn't the end point. You know, the final arbiter is the judge. More generally, however, practice reflects a general sense that the internal and external legitimization of professional hierarchies was often inconsistent with their desire to generate P-centric outcomes. Okay. So the complex intermingling between the internalized ethical values and account of good practice provided and the description of detached expectations around professional conduct also created tension that had to be managed. First, people recognized the importance and motivational force of their own ethical values and orientation, where self-conscious reflection of their situated position was seen as an inevitable and sometimes productive source for working through the messy complexities of these kinds of cases. A retired judge said the following: "I don't think we can divorce our own personal experience from the way that we do anything, whether it be a very technical area of law or whether it be this much more social aspect of law. I think the best we can do is to tell people why we've done something. If you can tell people why you've done it, you are in that way, and others are able to analyze whether your own values and life experience have been factors, or whether you've exercised your discretion in a more principled way with as little unconscious or conscious bias in it as is possible." However, there's also a degree of ambivalence to the extent to which a professional's own value sources ought to impact the legal practice of arguing, deliberating, and adjudicating. Whilst internalized altruistic motives were seen as expressive of values distinctive to the true mental capacity law specialist, that perspective also led to complex relationships with strongly held legal values associated with professional practice, such as impartiality, objectivity, open-mindedness, and fairness. The recognized legal imperative to provide representation to P, regardless of their disagreement with P's substantive commitments, presented another clear example of that tension. A small number of practitioners highlighted tensions with ways in which the other regarding motivation to help and advance P's interests had an uneasy dynamic with professional values associated with equal representation for all, where those motives were operationalized or indeed compartmentalized in representing and advancing the at times offensive beliefs, such as those concerning racism, relevant to assessing the person's best interests. More generally, a wide spectrum of views regarding the putative objectivity of decisions made in mental capacity law were expressed, highlighting for some the objective standard's inherent arbitrariness, for others, its presumptive necessity, and for yet others, its unpredictability. Representing the necessity view of the objective standard, one practitioner stated that the dangers of abandoning objectivity was evident in the implicit overdetermination of certain socio-cultural values in these kinds of cases, such as when middle-class values about middle-class people and the way that lovely middle-class people with lovely middle-class lives judge cases involving people who don't come from the same background. On the other side of the spectrum, skepticism of objectivity in mental capacity law may be linked to the extent to which people view their own values and their own reflexive stance towards these values as inevitable and productive sources. So this observation was present in the accounts given by barristers and judges. And two retired judges stressed how their own situated values were definitive and potentially constructive in their work. First judge: nobody is objective. I think the best you can say is that you try to be aware of your prejudices and you try not to let those suddenly become as if that's a given. If somebody says they're completely objective, I think they're fooling themselves. Another judge: I do think that the key is know then thyself, so that if you have a prejudice or an inclination, you must be aware of it. You must recognize it, and you must be on guard to, as it were, moderate its influence on your assessment. I think it's okay. We all have prejudices. All human beings are prejudiced creatures. The vital safeguard is to know your prejudices and be on guard. That's all you can do. You can't eliminate them, just need to recognize them and be on guard. So in summary, these people recognize the tension, I think, between a commitment to personal values and motivations, which for them were critical to good practice, and this complex legal requirement to maintain a detached on objective stance in relationship to the reasons being considered. Okay, to finish off, a few points for discussion. The human element that I've claimed best captures how my interviewees here think mental capacity law should be interpreted and operationalized in the courtroom, gestures towards a distinctive normative vision for good legal practice in this area, I think. It's founded upon personal motivational commitments and aligned with particular skills and character traits. It's also enacted in ways that foreground specific requirements in legal practice that have to be continually negotiated and managed in courtroom practice. I think this multi-layered account of the human element challenges overly reductive binary formulations of the values typically described as being in play in this area of law. For example, autonomy versus welfare. And it also captures how practitioners themselves frame requirements to relate to other professionals, social workers, other legal professionals, and to judges, to P, him or herself, and indeed to themselves and their relationship to themselves. The normative commitments underpinning the human element of mental capacity law infuse an evaluative stance with a professional performance that these people identified as being crucial to enacting what it means to be a good solicitor, a good barrister, or a good judge. Of course, important questions remain. Can this rich and expansive normative account of what good mental capacity law practice in the courtroom requires actually be robustly defended when we scrutinize it from a normative standpoint? Are these insights distinctive or unique to this area of law? Or could they also resonate with other specialist areas like family law, where we also see values as being front and center in the deliberative and adjudicative process? Do these insights and the very idea of the human element of mental capacity law practice idealize professional identity and professional work that is of uncertain real world validity? Does this strike you as realistic if you know anything about the judges and barristers working in this area of law? After all, these are just accounts given in an interview to us. How does this connect, this account, to legal practice in Singapore? Particularly because one thing I've noted, in contrast to the health and welfare cases that dominate in England and Wales, it's matters concerning P's property and affairs and the appointment of deputies that take centre stage in the Singaporean court context. Do local legal practitioners working in mental capacity law recognise any aspects of these accounts given by their counterparts in England and Wales? Do local clinicians recognise some similar concerns or the same traits or motivational elements when they think about how they're motivated to decide on behalf of their patients who lack capacity in day-to-day work? Can we connect the legal context here with the medical professional context, perhaps, or maybe not? Lots of questions to discuss, and I hope we'll be able to work through some of them together. Thanks, everybody, for your attention, and I hope that wasn't too long and involved. Thank you.
Thank you so much, Mikey, for that wonderful presentation, which I must say as a lawyer myself found super interesting, particularly in terms of certain findings. And maybe before we receive some audience questions, I think I will take the chance to start off on the question and answers. And I think my question is particularly on the normative elements, or rather the normative commitment in terms of including, say, collaborative or participatory values. And I found that very surprising, particularly within the paradigm of an adversarial or, a very battle plan kind of, environment that a courtroom creates, right? So whilst the process of litigation continues to signal this adversarial interaction, I personally find it very difficult to believe that these sort of normative values can be well incorporated within a traditionally hierarchical institution that focuses on, oftentimes very paternalistic tendencies as well, right? So, and this may not have been the focus of the study itself, but do any of the findings suggest that the traditional courtroom process should adapt itself to the specialist nature of these cases, or rather, is it that an entirely different process could be instituted outside of this adversarial litigation process, like an executive process maybe, or or an alternative dispute resolution process, for instance, where deliberations of mental capacity could take place?
Yeah, thanks, Mathavi. Two really, really good questions. Thanks, that's great. So on the first one, one thing I think it's important to recognize in relation to what these practices are talking about. I mean, aside from the judge, most of these people are working outside the courtroom for most of the time, right? So they're meeting P in the back spaces of committee rooms or in P's own home. So a lot of the kind of account of the courtroom here is broadening it out to social contact and social environments that are not actually taking place in that setting. So what they're not just describing here is the process of being in the court and working with a judge or working with each other in an adversarial encounter. They're talking about the backstage phenomenon of courtroom practice. And I think that's an important corrective to how we understand how courtrooms function, right? A lot of the work takes place behind the scenes in that sense. And so I think a lot of what can be explained perhaps in part by that backstage work. It might not feature so obviously in the forestage, in the foreground. That's one reason why we might think observational studies of courtrooms only give us a very partial picture to what's being negotiated, what's being performed. But I do think that's right. So there is a sense in how you connect all that hard, messy work, all that motivational, all that empathetic practice with the hard reality of encountering your opponent in the courtroom in the face of a judge. And I think there's a lot more work to be done in understanding that translational process there. I think your question about whether that process itself is fit for purpose, given what we're describing here, is a really important one. And I want to leave open the question about whether this account is robustly defensible. So you might think, we cannot defend what these judges and practitioners are saying. It is not appropriate to be practicing law like this. I'm open to that response by people on the call. I do think, and we are going to, in our project, go on to offer some defenses to this kind of an account. But if it is defensible, is the Court of Protection or the District Court in Singapore appropriate to resolve matters like this? Should there be increasing reliance on mediation, etc.? I think there has to be. I think the very nature of what it means to be formalized in the process of determining an outcome here, given what these judges and practitioners are saying, means that we have to, at least in part, think about a different kind of process for a different kind of venue and a different kind of set of rules for adjudication and practice more generally. Does that mean getting rid of the courtroom entirely? I don't think so, but it means, I think, positioning people's roles and responsibilities in quite different ways.
Absolutely. Thank you so much. So now maybe we will open up to audience Q&A. So anyone would like to go first? I think En Chong, Yuan Chong.
Hi, good evening, Mikey, Professor Mikey. Thanks for this talk. I think it was very, very interesting. I think we have really learned a lot. I think the question I'm asking is from this particular research or the different people that you ask, and perhaps the idea of a multidisciplinary team approach, because the Family Justice Court has been looking, because of therapeutic justice, at the multidisciplinary team approach where different professionals come in to solve an issue. You just mentioned mediation as well. Are you able to describe what is happening on the Court of Protection side right now, to whether the Court of Protection adopts a multidisciplinary team approach, and who are the members of this team, just to give us some ideas to what it could look like from the Family Justice Court perspective for the MCA side? Thanks.
Thanks, Yuan. Great question. I'm not an expert on the day-to-day nitty-gritty reality of Court of Protection work, I'm afraid. But I do understand that's quite limited in England and Wales, perhaps even more limited to places like Singapore, certainly to places like Japan, where I know that that kind of work is quite an important part of their family and social welfare law, the role of mediation. I don't want to overstep in my claims here. I do think, that our barrister colleagues would say, look, there's an awful lot of work going on behind the scenes that might take that kind of shape. I don't think formal procedures are often invoked to enable that. I don't know entirely. I think we have a lot to learn, perhaps from other areas. I mean, one of the long-term criticisms of the Court of Protection has been its closed nature. That Open Justice Court of Protection project is trying to open the doors to allow people to actually see what goes on. And what we see is quite a standard courtroom process, but we only see the presentation of it. We don't get to see all of that hard work that's going on that I talked about in response to Mathavi's question. Could we bypass some of that? Could we replace that? I think we probably could, but I don't think at the moment we're doing an awful lot of that. And I think there may well be a case for doing more. I think that's something we're going to have to consider as part of making our normative arguments in future papers on this project. Thank you.
So I'm Hilary from the law school. I am doing some research on mental capacity law. So I have two questions, and they touch on one of your questions at the end of your slideshow. So you mentioned, so your question was, does this account resonate with those practicing or enacting mental capacity law requirements in Singapore? And you said you noticed that unlike in the UK, cases locally tend to focus more on property and affairs. And I think part of that reason is because a lot of the medical end-of-life cases tend to be resolved by clinical ethics committees locally, as you probably already know. So building off of that, I guess my first question has to do with the role of family-centered care in court of protection cases in the UK, and whether you see family-centered care being a theme that appears based on your research and data. Because my understanding is that at least locally, family-centered care plays a huge role, and some local academics have proffered that as an element that distinguishes our local culture from the culture in the UK. So that's my first question. I'll get to my second question, I guess, after.
Thank you. Yeah, that's a fantastic question. It's great to put a face to a name as well. Nice to meet you properly. So yes, family-centeredness in this context. So good. I think that we're perhaps closer aligned than we might originally or initially think here. So, what I was stressing, I think, at various points was this important role that practitioners identified in evaluating, viewing, and interpreting the relationships around P. Now, most of those relationships are family relationships, of course, because P is tending to live with family members, and family members are often brought in to inform the decisions that are being made at various points in this process. And I think it's complex. So I think, legal practitioners definitely, so it's not the case that, the case gets to court and the family drops out of the scene. That's certainly not true. It's not the case that the medical professionals are sorting out the family matters and then they come to court and it's all about P. A fundamental aspect of what these barristers and judges were saying was that P's family needs to be sort of visible. P's relationship needs to be visible and assessed and scrutinized as part of our decision-making process. Sometimes that's about assessing the kind of the ways in which the family can support P. So making a best interest judgment, for example, we've got to take seriously the family's positionality, their point of view, how that might point towards P's best interest. That was a very common recurring idea in the work we did.
Right.
And another one was that the family could be detrimental to realizing the best outcome for P. So I think it's really important that this idea of P in relationship was central to how people understood the work that they were doing in the courtroom as well as just outside of it. So we're not just talking here about the case, the evidence around the family is presented, and the barrister runs with it. The barrister was looking at ways of understanding that relationship, engaging with the family if needs be, to make their arguments in ways that were responsive to the family's position. So I think we are seeing, and I think it's reasonable to say we're seeing a sort of family-centric element at least to what's going on in the eyes of these practitioners here. Yeah, thank you.
Thanks. So I guess to follow up on my second question, I noticed that based on some of the findings that you presented, the word compassion came up a lot, but there are some legal scholars that are quite skeptical of the role of compassion in the law. Compassion essentially being an emotion that motivates people towards caring action. And I think there are some people that are skeptical about emotion and emotion's role in the law. So I'm curious to hear your thoughts on whether compassion is a help or a hindrance to procedure and decision-making in the Court of Protection, and why.
Yeah, great. Thanks, Hilary. That's a really hard one. I mean, I think for me, the core insights in this piece of work are about the ways these various practitioners, almost commonly, not entirely, but almost commonly, foregrounded these emotional these emotional dimensions of their vision for good practice and how they enacted it. So I think from what we gathered, compassion sits alongside a range of similar for want of a better word, virtues that these people embodied, not just compassion, empathy, etc., etc. So I think for most of them, these were fundamentally part of what good practice demands. And I would say that, and we will go on to argue this in a subsequent paper, that this can be defended, and thinking about compassion as a performative requirement for good legal practice in this area can be defended. I think there's an argument for that. But we also saw that people were very much recognizing the clash between that more emotional dimension to people's work and this fundamental requirement to negotiate a kind of legal standard of objectivity, and how that kind of challenged them in various kinds of ways. Most, I think, endorsed the view that we need to retain compassion, retain empathy in practice, but they were certainly aware that wasn't an easy win or an easy account to give, and it had to be constantly negotiated alongside other normative value commitments that the law itself endorsed, and they recognize as being important to their work. So I think I'll go a little way to support that view, but I think we've got to take seriously the limits to a compassionate approach as well in this context, right?
Makes sense. Thank you so much.
So we have another question in the chat. What are the overriding thoughts in this Court of Protection UK? Is the primary or ultimately the responsibility of P, is that of the state? I think that is the extent.
Is that of the state?
Yeah, whether the primary responsibility regarding P is that of the state.
Yeah, so I think what these cases embody is a requirement to steward best outcomes for P in ways that the court is in charge of. The court is responsible for adjudicating as part of its overarching responsibility, but that manifests different kinds of value commitments. So, one of the complexities here is the judge's responsibility to steward P-centered, but also non-P-centered values. Some of those will no doubt reflect commitments that a society endorses, right? Value commitments that the society endorses. The obligation to protect P from harm, for example, is clearly an element of all of these cases and doesn't often emanate from P herself. So, the judge's core responsibility is to try to navigate those value commitments, but without any clear direction from the statute. So the statute, in the English democratic system here, operationalizes the best interest concept, but it doesn't provide much determinative guidance in how to interpret it. It certainly doesn't rank certain kinds of values. It just says, take into account past and present wishes, feelings, beliefs, and values, and any other consideration relevant in that context. What we see is people grappling with and struggling to negotiate a whole range of considerations that they think are rightfully in play, but don't obviously emanate from any clear source. Some of them come from themselves, as I try to argue. So there isn't an overarching role, I think, for the court to take here. The court is sort of finding its way as it goes on a case-by-case basis. The different judges, and I've heard this from other people in the court, the different judges will give you different decisions because of their personalities and their value commitments. Now, you might think that's deeply problematic from a rule of law perspective, but that's the way things seem to go here. And so it's a very complex and messy world, I think, and I think a lot of the data here illustrates that, I hope. Thank you.
All right, so maybe we have, I guess, time enough for a couple more questions, but maybe I take the chance to ask one more question, and this is regarding whether or not this study has any future plans to incorporate, say, P's perspectives or experiences within the deliberative process of the courtroom system, and whether those experiences are likely to be of any convincing factor in changing the courtroom system itself.
Yeah, thanks. That's a great question, Mathavi. I think the answer is yes. We obviously are guilty of the missing P here. P is not part of our empirical work, although is reflected in various kinds of ways through the accounts given, of course. We have a lot of data and a different paper being currently drafted that shows that when the judge or the barrister meets with P, it radically changes how they approach their work, how they assess things, and how they go about the business of the court. So there's a lot more to say about that. We don't have, of course, P's perspective on that experience. P sometimes comes to proceedings, but not very commonly in England and Wales, I think, as far as my understanding goes. It's difficult to collect empirical data from P's perspective just because of the fact that P lacks capacity, or maybe on the verge of lacking capacity in these cases. So asking P or finding information from P about relevant matters is going to be very difficult, I think, in this kind of context. It'll be difficult to get meaningful responses about that experience, right? That's not to say it's not possible, but it would be very empirically, a lot of empirical thought has to be given to how to capture that, I think. But we do have plans in a future project to think about, P's position in all of this from P's perspective, and doing some more anthropological work, perhaps in the courtroom, perhaps outside the courtroom, and looking at P's position in this, and how P's encounter with people shape things from P's perspective. So bear with us. It's not going to be part of this project, but it is hopefully will be part of future work.
Any further questions from the audience? If not, perhaps maybe we could come to a close of the session, unless, Mike, you have any further words to say?
No, thanks, everybody. Great questions. Really enjoyed hearing all your thoughts and getting a sense for local practice. So do send me an email. Do get in touch if you'd like to. I'd love to meet you and hear more about your work. I'm new to the country, so reach out and always love talking about this area of law and practice. So do get in touch. Thank you.
Thank you once again, Mikey, and to everyone else for joining us and contributing to this discussion. So we'll see you all at the next edition of the quarterly seminars in June. Bye-bye.